Hey everyone, welcome back to the VSO Gun Channel. It's great to be here as always. Thank you for tuning in. And I've got an update on the Rahimi case for you. Now, I know that there are other people that have probably covered this up to this point. You've probably heard some of this stuff already, but I was out today, so I'm giving you my analysis now. Now, this is 103 pages. I'm not going to be covering all 103 pages today. I've had an opportunity to read about a half of it. And there's some good nuggets in here thus far. I'm going to have to probably do a second video to cover it all. But today we're just going to cover the overview, kind of what went down, what happened. And I kind of also want to have a little bit of discussion about my opinions on this case. First of all, what I would say right out the gate is that if you were to assign traditional sides, like our side versus their side, then I suppose that you would probably say that this was a loss. But I'm also fundamentally uncomfortable with calling it our side loss because, as you're going to hear a little bit later in the video, this dude is an absolute, you know what, we're within the first couple minutes. So we'll just say that he is not a model citizen, if you will. And from the beginning, we have always kind of said that this was going to be a limiter decision on the Bruen decision. So what are the limits of the Bruen decision that we've been talking about so much for? And I think that it does place limits on it. Now, what we're going to do really quick is I'm going to go ahead and take a break, and then we'll come back and I'll present what the court said. Today's video is brought to you by XS Sites. I've been using their sites for years now. I gravitate towards their big dot sites, but they offer all kinds of profiles out there. I recently did a video detailing how the sites work at different ranges. Go check that thing out. I'll have it listed in the description box down below. And special thanks to XS Sites for making today's video possible. Okay, so as I said in the intro, this is 103 pages, and in that 103 pages, we got the main opinion, concurring opinions, and a dissenting opinion. Roberts penned the main opinion, and then the dissenting opinion, one was for one side, quote unquote, and one was kind of for the other side. And then the dissenting opinion was penned by Clarence Thomas. So I'm, again, sure that there will be some good nuggets by the time I get down to Clarence Thomas. What the court actually said. Respondent Zachary Rahimi was indicted under 18 U.S.C. 922G, a federal statute that prohibits individuals subject to domestic violence restraining order from possessing a firearm. A prosecution under Section 922G may proceed only if the restraining order meets certain statutory criteria. In particular, the order must either contain a finding that the defendant represents a credible threat to the physical safety of his intimate partner or his partner's child, 922G, citation, or by its terms, explicitly prohibit the use, attempted use, or threatened use of physical force against the individuals. Rahimi concedes that the restraining order exists, but argues that its face violates the Second Amendment. While Rahimi's case was on appeal, the Supreme Court decided New York State Rifle and Pistol Association v. Bruen. In light of Bruen, the Fifth Circuit reversed, concluding that the government had not shown that the section of the law fits within the nation's historical tradition of firearms regulation. You see what we got going on here? Bad dude does some stuff. During his prosecution, the Bruen decision comes down. The circuit court's like, we don't actually know the limits of this thing. And as far as we know, no text, history, and tradition on this. The court continues and says, held when an individual has been found by a court to pose a credible threat to the physical safety of another, that the individual may be temporarily, keyword temporarily, disarmed consistent with the Second Amendment. Since the founding, the nation's firearms laws have included regulations to stop individuals who threaten physical harm to others misusing firearms. As applied to the facts here, Section 922G8 fits within this tradition. The right to keep and bear arms is among the fundamental rights necessary for our system of ordered liberty. The right, however, is not unlimited. I disagree, shall not be infringed. The reach of the Second Amendment is not limited only to the use of arms that were in existence at the time of the founding. Rather, it extends prima facie to all implements that constitute bearable arms, even those that were not yet in existence. Ooh, that's a good one. I like that one. By the same logic, the Second Amendment permits more than just regulations identical to those existing in 1791. Under our precedent, the appropriate analysis involves considering whether the challenge regulation is consistent with the principles that underpin the nation's regulatory tradition. A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. Why and how the regulation burdens the right are central to this inquiry. Section 922G is constitutional as applied to the facts of Rahimi's own case. They're drawing it kind of narrowly there. Rahimi has been found by the court to pose a credible threat to the physical safety of others, and the government offers ample evidence the Second Amendment permits such individuals to be disarmed. The court reviewed the history of American gun laws extensively in Heller and Bruin. At common law, people were barred from misusing weapons to harm or menace others. Such conduct was often addressed through ordinary criminal laws and civil actions, such as prohibitions on fighting or private suits against individuals who threaten others. By the 1700s and early 1800s, though, two distinct legal regimes had developed that specifically addressed firearms violence: the surety laws and the going armed laws. Surety laws were a form of preventative justice, which authorized magistrates to require individuals suspected of future misbehavior to post bond. If the individual failed to post bond, he would be jailed. If the individual did post bond and then broke the peace, the bond would be forfeit. Surety laws could be invoked to prevent all forms of violence, including spousal abuse, and also target the misuse of firearms. These laws often offered the accused significant procedural protections. What the court is saying here is that there is a constitutional basis through the text, history, and tradition in the United States that if someone poses a threat to the general populace or to individuals specifically, that they can be, and I quote, temporarily disarmed. And the court says that the historical analogs say that there must be significant procedural protections for the person in question. As in, someone can't just be wrongfully accused. They have to have demonstrated that this is actually the case. And I think that's where probably a lot of people will argue about whether or not someone could potentially wrongfully accuse someone of domestic violence. We hear about this kind of stuff all the time. It turns out to not be a thing, and that is unfortunate. The court says, hey, as long as they've had an opportunity to address this in open court, then that's enough. And that's basically what they come down to. Now, what I want to do here is the court said that this applies to the facts of Rahimi's case, and they ultimately end up remanding the case back down. So what I want to do is read for you the circumstances of the case, and I want you guys to say in the comment section down below whether or not you believe that this individual, due to the facts of the case, is rightfully considered to be a threat to those around them, specifically the people in which he has a domestic violence restraining order against him. Here we go. In December 2019, Rahimi met his girlfriend, CM, for lunch in a parking lot. CM is also the mother of Rahimi's young child, AR. During the meal, Rahimi and CM began arguing, and Rahimi became enraged. CM attempted to leave, but Rahimi grabbed her by the wrist, dragged her back to his car, and shoved her in, causing her to strike her head against the dashboard. When he realized that a bystander was watching the altercation, Rahimi paused to retrieve a gun from under his passenger seat. CM took the advantage of the opportunity to escape. Rahimi fired as she fled, although it is unclear whether he was aiming at CM or the witness. Rahimi later called CM and warned her that he would shoot her if she reported the incident. Undeterred by this threat, CM went to the court to seek a restraining order. In the affidavit accompanying her application, CM recounted the parking lot incident as well as other assaults. She also detailed how Rahimi's conduct had endangered AR, which is the kid. Although Rahimi had an opportunity to contest CM's testimony, he did not do so. On February 5th, 2020, the state court in Tarrant County, Texas, issued a restraining order against him. The order, entered with the consent of both parties, included findings that Rahimi had committed family violence. It is also found that the violence is likely to occur again, and that Rahimi posed a credible threat to the physical safety of CM or AR. Based on these findings, the order prohibited Rahimi from threatening CM or her family for 2 years or contacting CM during that period except to discuss AR. It also suspended Rahimi's gun license for 2 years. If Rahimi was imprisoned or confined when the order was set to expire, the order would instead terminate either 1 or 2 years after his release. In May, however, Rahimi violated the order, approaching CM's house at night. In November, Rahimi threatened a different woman with a gun, resulting in a charge for aggravated assault with a deadly weapon. And while Rahimi was under arrest for the assault, the Texas police identified him as a suspect in a spat of at least 5 additional shootings. The first, which occurred in December of 2020, arose from Rahimi's dealing in illegal drugs after one of his customers started talking trash. Rahimi drove to the man's home and shot into it. While driving the next day, Rahimi collided with another car, exited his vehicle, and proceeded to shoot at the other car. 3 days later, he fired his gun in the air while driving through a residential neighborhood. A few weeks after that, Rahimi was speeding on a highway near Arlington, Texas, when a truck flashed its lights at him. Rahimi hit the brakes and cut across traffic to chase the truck. Once off the highway, he fired several times toward the truck and a nearby car before fleeing. 2 weeks after that, Rahimi and a friend were dining at a roadside burger restaurant when the restaurant declined his friend's credit card. Rahimi pulled his gun and shot into the air. The police obtained a warrant to search Rahimi's residence. There, they discovered a pistol, a rifle, ammunition, and a copy of the restraining order. Now, again, as I stated previously, we know that sometimes these domestic violence accusations are indeed false, and sometimes they're used as a mechanism to get over someone in a domestic dispute, particularly during divorces. However, do any of you believe that this dude was anything but a danger to his environment around him? I think that this dude has demonstrated that he does not have a regard for the safety of people around him, and he's willing to use his firearm inappropriately on multiple occasions to threaten and potentially kill, injure, or maim other people. This is, in my opinion, someone who likely should be incarcerated for a long period of time, and thus, while they are incarcerated, should not have access to their weapons. As I mentioned, this thing is 103 pages. I'm sure that there will be some good nuggets to mine out of this. We've already seen some good ones already, as they pertain to defense of the Second Amendment, both legislatively and judicially. As far as this case is concerned, I don't think that any reasonable person would say, yeah, that dude should be walking around with weapons. Okay? I really just don't think that anybody can say, hey, this person is actively committing crimes, they should be armed. Just like we say, in the historical analogs, there's precedent for if somebody is actively intoxicated, you can disarm them until they sober up and then they get their weapons back. I think this person has demonstrated that they are willing to shoot into things that are occupied by people with complete disregard to their health and safety. And that is a pretty decent basis to remove somebody's weapons. As it relates to the broad sense of things, as it relates to domestic violence restraining orders, and if they are illegal, I see the abuse capacity there. I'm hoping that a thorough read of this case, all 103 pages that I will be doing for you guys, and then doing an analysis later, will shed some light on that decision to support those sort of things, and also provide staunch limits for the use of that sort of thing to disarm citizens of the United States. Anyway, that's what I got for you guys here today. Sound off in the comment section down below. I'd love to hear what you guys think about this.